I will go ahead and call this second case of the morning. This is also a 15-minute mini oral argument on the application Seoul versus Michigan Economic Development Corporation. Mr. Goldberg, you may attempt to reserve some of your 15 minutes for rebuttal, but we ask you to try and keep track of that yourself. And if you are ready to go, you may proceed.
Thank you, Your Honor. This case is a case brought pursuant to the Freedom of Information Act. And of course, the Freedom of Information Act is defined in the statute. The policy behind the Freedom of Information Act is defined in MCL 15.231, is that the public policy of the state that all persons, except those persons incarcerated in state or local correctional facilities, are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and public employees, consistent with this act. The people shall be informed so that they may participate in the democratic process. And in Hagan versus Department of Education, this court has consistently recognized that the thrust of the FOIA is a policy of full and complete disclosure as expressed in the Act's statement of public policy. I begin with this because I think, well, much of the briefing in this case dealt with more technical aspects of questions of statutory construction. I think it's important to not lose the forest through the trees, that this case deals with what are called mega tax credits. Mega tax credits are refundable tax credits, meaning if the credit is greater than the tax owed, the state will pay the cash difference to the company as a refund, whether or not the company has tax liability. A 2018 legislative report on the mega tax credit noted that through the year 2032, corporations stand to claim over $6.3 billion in mega tax credits, depriving Michigan residents of the potential benefits from that income in public services, education, etc. On information and belief, the auto companies are by far the greatest beneficiaries of these credits, and we believe that GM alone receives more than $2 billion over a 20-year period in mega tax credits. What I would submit to the court is that the idea that the Michigan State Economic Development Corporation can make a private agreement with GM to not disclose these massive tax breaks to this corporation, these massive tax credits to the corporation, really flies in the face of everything that FOIA is about. Whether people believe these tax credits are a good or bad thing, the public has a right to know them, know what they are, know the amount, and be able to position to debate their efficacy. And by denying this from the people, by denying this knowledge to the people, I would contend, and plaintiff contends, that this is really flies in the face of everything that FOIA is about and really contributes to a lack of confidence in the government. Of course,
Mr. Goldberg, let me interrupt you because folks might have questions and I don't want you to use up all your time. And I'll start with Justice Viviano.
No questions. Thank you, Counsel.
Justice Bernstein.
Hi, Counsel. Good morning. I have no questions for you at this time.
Justice Clement.
No questions.
Justice Cavanagh.
No questions.
Justice Welch.
No questions. Sorry.
No questions? I'm sorry.
Question.
Oh, Justice Zahra.
I guess I'll throw one out. I'm a little bit concerned, I guess, that your interpretation, subsection 11 of the statute would become an exception that swallows the rule as a whole. So if we were to adopt your interpretation, what sort of information would continue to be exempt from disclosure under subsection 9?
Certainly. I mean, subsection 9 deals with financial and proprietary information. But again, as you note, as you reference, subsection 11 specifically exempts from that definition and any agreements that the fund is authorized to enter into. We were very clear in this FOIA. Our client is not interested in all the private financial information that General Motors may have submitted to the Michigan Economic Development Corporation for them to make the determination of what is the amount of the credit. We did not ask for that, and we specifically did not ask for that. We did not ask for all their
Slow down, Counsel. You're not answering the question. What sort of information would continue to be exempt from disclosure under subsection 9 if we adopt your interpretation of subsection 11?
I think financial information that deals with their internal records that the Michigan Economic Development Commission used in making that determination would still be exempt. What's not exempt is that the agreement that they made with GM, which includes the amount of the tax credit.
I see. Okay, thank you very much.
Counsel, I'm struggling, like Justice Zahra, to make sense of how to reconcile Section 9 with Section 11. And the Mackinac Center mentions in its brief MCL 205-285, which makes it a $5,000 penalty for a member of the legislature to disclose the total tax credit amount under the MEGA Act. And that feels curious. That's a 2009 statute. And my understanding from the briefing is that this information was regularly disclosed until 2009. Then all of a sudden in 2009, it's a $5,000 penalty if a member of the legislature who gets the information as a matter of law discloses it. And that feels to me to support the background norm of not disclosing it when I'm trying to make sense of 9 and 11. Can you tell me what you think about?
Yes, and I'm less of an expert on the whole history than the Mackinac Center, but it was clear from his briefing, and I read it very carefully, that it would not preclude any of the tax credits that are subsequently given to them since then. One thing that's important to note, there have been changes in the law. The law originally came, mega tax credits were administered by the Michigan Economic Government Authority. And there still is a Mega Tax Act that defines the nature of those tax credits, but now they've been turned over to administration to the Michigan Economic Development Corporation. And they were done by an executive order of Governor Engler in 2012. So I believe that under the current law and under the current regulation, what we're under now is that they are under the administration of the Michigan Economic Development Corporation. And so their rules, and that's what the Mackinac Center contended also, are determinative. And we believe that under their rules, let's be clear, what the Michigan EDC is asking for is a very broad interpretation of the statute. The statute, they rely on the statute, the exemption for records or MCL 15.24331D that defines records or information specifically described and exempted from disclosure by statute are exempted. And of course, all the law makes clear that exemptions are to be narrowly construed. They're to be construed in favor of disclosure.
I might not have been very clear. I guess what I'm trying to say is I agree with all those background norms, but if I'm having trouble reconciling sub 9 and sub 11 and trying to make them make sense together, and then I see there's this other statutory section that says that a member of the legislature who discloses exactly the information that your FOIA seeks to disclose has to pay a $5,000 penalty, doesn't that indicate that maybe we resolve this or we reconcile this conflict not in favor of disclosure? I really don't know. I'm asking.
Yeah, well, that's a good question, and I could brief it further. I mean, I became much, again, I do not claim the expertise at the Mackinac Center, but when I read their brief, what he was very clear was that may have done with certificates in years past, but in terms of the current certificates that go through 2032, that statute would not be applicable, and that they can certainly disclose those amounts, and we would like to see those amounts. And in fact, I should be clear, they've actually disclosed that amount. They published them on their own website in an amended disclosure, which I referenced in my brief and in the motion that we filed. They actually disclosed that amount. So obviously they feel they can disclose them. They disclose regularly, and we've attached it. The MEDC discloses mega tax credits regularly on their website. I've attached their reports that disclose them. So clearly they have the ability to disclose them. They've been disclosing them. For some reason, they evoked an exception in this case, and we believe that exception is a dangerous exception because it sets a precedent that when a corporation wants to ask for some special treatment, and really special treatment is a contradiction of what proprietary treatment, non-proprietary treatment should be about. They're willing to do it, and we think that's a dangerous precedent.
Thank you, Mr. Goldberg. Does anybody have any additional questions for Mr. Goldberg? All right, you may reserve some time for rebuttal if you'd like, or you may. Okay, great. Mr. Vernon.
Thank you, Your Honor. Good morning, and may it please the court. My client produced over 300 documents in response to Mr. Soul's FOIA request, redacting just one piece of information, the total amount of GM's tax credit. And it explained why. FOIA exempts from disclosure material that is exempt from disclosure by another statute. And another statute, the MSF Act, prohibits the disclosure of portions of records that are prepared by the MSF and that relate to an applicant's financial data if an applicant asks and the MSF agrees to keep that information confidential. There's no dispute that the total amount of GM's credit was prepared and used by the MSF, that it relates to GM's financial data, or that GM asked and the MSF considered and agreed to keep it confidential. And both sides agree, and Mr. Goldberg said again this morning that the MSF Act is unambiguous. So it must be enforced as written. And the Court of Claims and the Court of Appeals agreed that its plain language required the MEDC to redact the total credit amount. To answer the two questions posed by this court's order for supplemental briefing, first, the total amount of the tax credit is exempt from disclosure because it relates to GM's financial data and because the MSF board agreed to keep it confidential. And second, Section 11 does not require the unredacted disclosure of the mega agreement. It says that documents evidencing agreement can't be exempt from disclosure, but information within those documents can be. And per Section 9 in the Bradley case, it must be here. So it's true that Mr. Soul and the Mackinac Center don't like mega tax credits and perhaps don't believe that they're sound policy, but this case is not about the soundness of that policy. This case is about the interpretation of the statute according to its plain meaning and a contract according to the party's intent. And on those issues, we believe the Court of Claims and the Court of Appeals got this right. And that's why we ask you to deny Mr. Soul's application for leave.
Thank you, Mr. Vernon. Let me see what questions my colleagues have. Justice Viviano.
Counsel, how can your position be reconciled with Article 9, Section 23 of the Constitution?
Well, the Mackinac brief raises this constitutional issue, and I note that this case has been pending for 3 years, and at no point has Mr. Soul raised a constitutional challenge. So I don't think this issue's been preserved, and we think it would be improper for the court to tackle it now.
Let me just jump in, because and when we're interpreting the statute, the Constitution's been around since 1963, and so this provision might influence our interpretation of the statute if the interpretation we came up with, or the one that you're urging, comes up against the Constitution. So even though they haven't raised it, isn't it something we should consider in trying to decide what the proper interpretation of the statute is? In other words, wouldn't we want to avoid a constitutional conflict in our interpretation?
But as Mackinac notes, this provision has never been squarely considered by the court. The one case that addressed it from more than 50 years ago seems to suggest at best that what it means is that the public is entitled to a statement of revenue and expenditures of public monies. That still doesn't mean all financial records should be available. It doesn't mean all without redaction. And it doesn't mean the specific records relating to an individual taxpayer. In fact, the one case, Grayson, that looked at the constitutional provision 50 years ago had some trouble with this. It said it strains credulity to think that the framers meant to allow the public to inspect every application for licensure and every writing evidence of receipt or expenditure, because that could serve as a tool to harass. So given that the issue was not raised and the facts of this case certainly don't warrant or justify that it be addressed here, we don't believe, having not been raised, because it doesn't move the needle on the case with these facts. So we don't think it would be appropriate for the court to consider here, and we don't think it's implicated either.
On that last point, I guess, where we're talking about a large expenditure of public funds, in essence, these credits. And your view is that's not covered by, just so I'm clear, that's not covered by this provision of the Constitution? It talks about, all financial records, accountings, and audit reports and other reports of public money shall be public records and open to inspection.
The distinction between FOIA and the constitutional provision is an important one, because what the constitutional provision seems to say is there should be this general summary, and that's what the language says, and that's how the case is interpreted. So does that mean that the state of Michigan should provide a general summary of its total expenditures? It certainly doesn't say that the individual and specific records on a specific application for a specific taxpayer have to be disclosed. And we think that that interpretation would fly in the face of the legislative intent. Especially here, we do not have an unambiguous statute. There are FOIA exemptions that call for balancing or harm assessments. There is one in subsection N that deals with law enforcement records. So there are exemptions that have language like, unless the public interest in disclosure outweighs other public interests. But this provision doesn't have that. And when language is included in one section of the statute but excluded elsewhere, we must presume that the legislature did that for a reason. Here we have a legislatively created exemption that expressly allows a state agency to avoid its duty to disclose information. And we don't think it would be appropriate for the court to engage in a construction that's contrary to that plain language.
All right, thank you, counsel.
Thank you.
Justice Bernstein.
Hey, counsel, good morning. I just want to follow up on what Justice Viana was asking. And you know me, I like to just kind of keep things very simple. And in this situation, just following up to Justice Viana, the simple kind of question that I have for you is, does this going to the constitutional question, I realize, what you've engaged with my colleague. But at the end of the day, what is being asked is how much money did General Motors get in tax credits? It's one of those situations where the taxpayers basically are the ones who are paying the bill for this. And the question is a relatively simple one, which is, how much is it? And I guess my question to you is this common sense, right? That ultimately a major corporation shouldn't have to divulge the revenue stream that's getting or the amount of money it's getting from the taxpayers. Simple question, how much are you getting? Why is it in a commonsensical perspective that information that shouldn't be released?
Well, the simplest answer I would say would be that the statute says what can be released and what can, and it specifically says that if there's information that relates to the financial information that an applicant submits, and the applicant requests and the board considers it and decides, no, we can keep this confidential, we have to keep this confidential, then that plain language needs to be interpreted as written. The fact is, the state of Michigan also has an interest in ensuring that businesses move here and grow here and employ Michiganders. And when the legislature created this statute and program to incentivize this behavior, one of the things it promised to businesses is that when they apply for this incentive, if there's sensitive information that they're submitting, they can request that and the information that relates to it remain confidential. And that's what happened here. The MSF board agreed that the information would remain confidential. And outside of that, it feels like we're talking more about policy, and that policy decision was already made by the legislature.
Counsel, thank you.
Thank you.
Justice Clement.
Good morning. What is your response to Mr. Goldberg's assertion that there's regular disclosure of the mega tax credits, and then in this specific situation, there was an amended disclosure related to the GM cap? And how are we supposed to take that information and use it when we're looking at 9 and 11, or does it not matter?
Well, I believe that what Mr. Goldberg calls the amended disclosure was the later disclosure of the remaining value of the tax credit, which is different than the total value. You can take the total value and figure out the financial information that GM submitted, which was part of the concern and part of the reason why, since that related to the information it submitted, they asked that it be kept confidential. But you can't do the same thing with the remaining value. And on the question of the interplay between 9 and 11, the Court of Appeals, we feel, got this right. Section 11 says that a document can't be considered financial or proprietary or otherwise exempt from disclosure. But that has to be read in harmony with Section 9, which says that a portion of a record or a portion of the document must be exempt from disclosure if it relates to financial information. And as the Court of Appeals explained, a document is not the same thing as information or a portion of the document. And as this court held in Bradley v. Saranac, when a document must be disclosed under FOIA, but contains information that falls within one of the exemptions, then the redaction is appropriate. And that's why we feel this redaction was appropriate and mandated here.
Okay, so just to clarify, so the amended disclosure was just the remaining value. And so MEDC's contention is that total cap, that it's directly related to the financial document, and if someone gets that number, they can go backwards and figure out the financials that the company is trying to keep confidential. When it's just the remaining value, that's not possible. Is that accurate?
That's correct in my understanding, because what they don't know is the amount that's been spent from the initial total value to the remaining value.
Okay. And then at what point is MEDC comfortable sharing what the remaining value is? I mean, you enter into an agreement, is it after 1 year? Or is there a determination that's made where you're comfortable sharing what the remaining value is because it's a number that can't be extrapolated out for someone to be able to figure out what the total cap is?
That's my best answer, Your Honor. And I don't know what specifically the discussion or understanding was between the MEDC and GM about the ability to share that remaining information, other than the fact that with the remaining information, there was a sense that it would not disclose the sensitive financial information that GM initially submitted with this application.
Okay, great. Thank you.
Thank you.
Justice Cavanagh?
Good morning. I guess I want to sort of ask the flip of the question that Justice Zahra asked of Mr. Goldberg. And under your interpretation of subsection 11, or I guess the broad interpretation of relates to in subsection 9, what would be an example of a document referenced in subsection 11? What would be an example of a mortgage, a venture, lease, or other agreement that wouldn't relate to confidential financial information?
I think that in this case, we have an example of the actual mega agreement itself. So the entire document may relate to may relate to aspects of the application or financial information. And under 11, the entire document, when I say the entire document, the document itself would have to be disclosed. But under Bradley and reading it in conjunction with subsection 9, if there's information that's specifically exempt from disclosure, that information would have to be redacted from the document. And the mega agreement was produced here with that information redacted. And the reason subsection 9 kicks in is because it very specifically relates to the total value of the tax credit. So you've got the FOIA exemption for information that's exempt by other statutes. You've got subsection 9 that says that if information relates to financial information submitted and the board considers and agrees that it's confidential, then it's exempt. So that small piece of information is the information called for in subsection 9 and thus has to be redacted, even though the agreement may have to be produced under 11.
Is there information in the agreement without the cap or without the credit amount that is useful? I mean, is there a point to disclosing the document other than the cap itself or disclosing the amount?
There are the terms of the agreement. there are, and I can't remember how many pages the agreement was, but there is a significant amount of information in there. The only thing that was redacted was the total value of the cap. The utility of that information to Mr. Soul, I'm not sure, depending on what he needed the agreement for, but there is a significant amount of information in the agreement, yes.
Okay, and then final question, tell me why I would be incorrect to, if I'm trying to square subsection 9 with subsection 11, why am I incorrect to say that I read 9 to say this is information submitted by the applicant? This is, for lack of a better word, like, here's all the guts, here's the parts that go into this. MEDC, you then produce the result. The document says all this stuff goes in, that can't be disclosed if GM says that's confidential and MEDC agrees. But what MEDC has decided, the results, the final product of you get X amount, why is that not covered in 11? The amount, the result is what comes out. That's public information. But sort of what the why and the how and the, how many employees and what they pay them and where they're, what they're doing, their business plan, their financial information to get to that number. That's covered by 9, but the result is covered by 11, and that is publicly disclosed.
Well, I think the answer to that question comes from the language in subsection 9. And the statute could have been written in a way, it could have easily been written in a way that limited the exemption solely to the financial and proprietary information submitted by the applicant, but it wasn't. Subsection 9 very specifically says that any portion of a record or other data received that is prepared, used, or retained by the fund. So that the part of the language that says that was prepared by the fund, that's not information that GM submitted, that's information that's prepared by the fund. And if that relates to the financial or proprietary information and it's considered by the applicant and acknowledged by the board to be confidential, then section 9 by its plain language says that it's exempt from disclosure.
Okay, thank you.
Thank you.
Mrs. Welch.
Yes, thank you. I'm wondering, counsel, does it make a difference, the actual agreement here, where you all responded and did the redactions, defines tax credit cap as the total value of mega tax credits that may be claimed, and then tax credit certificate as something different. And I'm just wondering if that has any relevance in this case and how we look at the case.
No, I don't believe so, because the confidentiality agreement specifically acknowledges, yes, the total value of the credit is going to remain confidential. The intent of the parties is clear on that, and there's nothing there's nothing that requires the certificate to be disclosed publicly either. I think the statute actually says the certificate has to be disclosed to GM, but it's the same analysis that if there's information that reveals the total value of the tax credit, that portion of the information needs to be redacted.
Okay, thank you. The other point that has been made in this litigation is sort of concern about competitive harm, and that would be one of the motives for obviously having confidentiality in this context. I guess I'm wondering why exposing the amount of this tax credit cap would be harmful to GM. Why would that be harmful from a competitive standpoint?
Yes, that's a good question. So there are aspects of GM's or any applicant's finances that are highly sensitive and that a competitor may want to know. And using as an example, if there were marginal costs at a facility, if there were certain cost benefit analyses involved in an expansion, those are all factors that are part of the mega tax application and that factor into the formula to determine the amount of the credit. And that's information that is sensitive and you wouldn't want in the hands of a competitor. So
agree that the documents submitted with that sort of information, I think probably pretty clearly covered by the statute. But the tax credit cap is just frankly this big number. It's just a cap. It's the amount that GM, if it upholds its end of the bargain over time, can get in total. I mean, can we really extract out from that all of the underlying information from just that number? Admittedly, I'm struggling with that.
Yeah, and I'm not an expert on the formula, but I understand that those who are, and those who understand the formula are able to back out the information that's submitted and figure out what it is. I don't know if reverse engineering is the right word, but yes, you can take the formula if you have the total value and figure out what some of those inputs were. And if those inputs were sensitive financial information, that would be concerning to GM or anyone else.
Okay, thank you.
Justice Zahra.
Questions? Thank you.
Thank you, counsel. We used up all of your time and then some. So I'm going to let Mr. Goldberg have his rebuttal time.
Yes, thank you. Let me just raise a few points in rebuttal. First, I want to make clear that they didn't disclose 1 penny of the tax credit, not the total tax credit, not the tax credits that were forthcoming, not the tax credits for any year. They only chose to do this amended report a couple years later in a PR stunt to get some good publicity. But when we asked for a FOIA, and they certainly could have redacted parts of the amounts, or they could have claimed they had a duty to redact it, they didn't produce any financial information to us whatsoever. Secondly, I think it's really important to look at the statute. If we want to look at the statute, a FOIA statute, the presumption in any is always that the exemptions are to be read broadly. They're to be read in favor of disclosure, and they're to be narrowly construed. What they've done is they've taken a line. There's nowhere in the statute that says they cannot disclose the total amount of the tax credit or the value of the tax credit. It simply does not say that. That is not the plain language of 125.2059. What it says that it relates to proprietary information, or relate, and what the defendant has done is taken a very broad definition of relate and said that they broadened that definition to include complete non-disclosure. I think what the justices have asked is exactly to the point. From the public point of view, the public isn't trying to discern every detail of GM's information. The public is concerned with how its tax dollars are being used or being expropriated, how our schools are affected by GM, a big corporation, getting billions of dollars in tax credits. And that's the issue. And that's not, and nowhere does that implicate the day-to-day runnings of GM. Secondly, in terms of the competitive, and that's an important point too, proprietary information under the statute, inclusive language that the release may cause the applicant significant competitive harm. If you look at the brief I submitted, it includes a list of the tax credits that were given to multiple corporations. I would submit that GM has been given a competitive advantage by the exclusion in this case. They disclose this information for corporation after corporation, but General Motors, because of its special position, whatever, gets a special advantage. And I would also submit that, as the justice very clearly pointed out and asked, well, this is an agreement. What we're asking for is the agreement for the amount of the tax credit. We're not asking for all the details that went into it. We're asking for the agreement. That's an agreement, and an agreement is specifically excluded from being proprietary information under MCL 125.20511. So I would submit that based on, and the other point I will make, the statute that was referenced earlier was never raised about the legislative, was never raised in their defense. The defendant strictly relied on 125.205 and the FOIA exemption in its defense to why it did not have to disclose this. That's why we didn't respond to that issue initially. So I would submit, based on the statutory construction argument clearly favors under the kind of construction that must be done in a FOIA case, the disclosure of this information, and fundamentally it goes back to what was stated by Justice Bernstein, which we feel very strongly about. The logic of it It defies real logic. It defies common sense, and it defies basic government. That the people, that corporations are allowed to exclude information from the people. I want to make last point I want to make. I studied cases, and there's a good case on this called Stone versus Michigan Bureau of State Lottery, and where the Supreme Court, the Michigan Supreme Court, has invoked exemptions against disclosure in similar cases. It's where they have a personal implication. In other words, if GM was there was a case where it was held that the individual winnings of every lottery winner didn't have to be disclosed because they had because those were personal. That was personal information. But we're not talking about personal information here. We're talking about a corporation. I don't think we accept this idea that corporations are the same as an individual, that they invoke the same privacy rights as an individual. And actually, if you look at most of the exemptions under FOIA, they deal with protecting privacy rights, protecting the rights of personnel, protecting the right of officers under investigation. But this is not a personal privacy right. This is a corporation getting a huge tax break from the state. And I think the debate over this tax break is a debate that's in the public domain, and for the public to engage in this debate, they have a right to know what the figures, what they're dealing with. And that's exactly why we asked for this, for the FOIA in the first place. We asked for it in the context of GM announcing many plant closings. That's why Mr. Soul asked for this. And we believe this could have been a factor in dealing with this issue. And whether you favor these tax breaks or not, that's a public debate. And to have that debate, the public has the right to know what they're dealing with. Thank you for your time.
Thank you, Mr. Goldberg. Thank you, Mr. Vernon. The case will be submitted.